Skip the courtroom drama. Who needs subpoenas, juries, and witnesses? Mediation lets you hammer out a deal on your terms, fast, private, and far cheaper than trial. Also, before you go to trial, the court will almost certainly require you to attempt mediation first, so you might as well take advantage while you're there. Here's what to expect and 10 simple steps to make it work for you. Sometimes the parties agree on a private mediator. Other times the court signs an order of referral that names the mediator or directs you to a dispute resolution center in your community. Either way, the mediator must be a neutral third party with no interest in the case. If you're choosing a mediator, choose someone who has a reputation for listening, but who can also be tough if one side, even if it's you, can be a little hard-headed. Sometimes it helps to have a neutral party tell you that you're being stubborn. An important thing to know is that the mediator has no power to decide the case, only to help you reach your own agreement. The mediator's job is to help the parties reach an agreement by keeping the conversation moving. Everything said in mediation is privileged. These are settlement discussions, and the rules of evidence prevent settlement offers from being used at trial. Depending on your state, there are also likely specific laws that prevent anyone from testifying about what was discussed in mediation. Those rules allow candid discussions of weaknesses, risk, and creative solutions without fear that a stray remark will haunt you in court. So, when you're mediating, take a step back from your trial position and take a hard look at your own case, warts and all. The confidentiality of mediation gives you a chance to offer some concessions that won't be held against you at trial. Your attorney will prepare a confidential position letter for the mediator outlining the facts, claims, defenses, and prior offers. You should gather key documents like contracts, emails, financials, or photos. Identify your needs versus your wants. Decide your realistic settlement range and the authority you will bring to sign. Block off the entire day. Successful mediations often run past business hours. Some of my most successful mediations were because I prepared like I was going to trial with a binder of exhibits for the mediator to reference during their discussions with the other side. Also, it helps when the other side realizes that their attorney was outdone by your attorney, because then they'll wonder just how prepared their attorney will be when it comes time to go to trial. Most mediators begin with everyone in the same room. But if it's a family law case with a history of violence or intimidation, then there likely won't be a joint session. In this joint session, the mediator explains the ground rules, then each side gives a short opening statement. This is not a closing argument. Keep it professional, factual, and forward-looking. The goal is to frame the dispute and show you are prepared, reasonable, and willing to negotiate. Honestly, I like to use this time to speak with all of the parties to explain that us attorneys get paid to talk and that there will be plenty of time for us to talk if we go to court, but that right now is the time for them to talk to each other. I tell them that us attorneys will be quiet and take notes while they do their best to work things out. Then, if they reach an agreement, then us attorneys, as officers of the court, have a duty to draft the agreed order or settlement agreement in a manner that ensures everyone gets what they bargained for. Surprisingly, when you get the attorneys to just shut up and get parties to actually sit down in the same room during this joint session to just talk to each other, a lot can get accomplished in a short amount of time. If the opening joint session isn't fruitful, then you and your attorney move to a separate room and the other side does the same. From there, mediation becomes shuttle diplomacy. The mediator carries offers and counteroffers back and forth between your respective rooms. What you tell the mediator in caucus is confidential unless you authorize disclosure. This is sometimes helpful when you have some wiggle room in your offer, as you can instruct the mediator to offer X, but that you're likely to settle for Y. This allows the mediator to find out what issues can be agreed upon and encourage each of you to meet closer to the middle. Negotiation is a lot more of an art than a science. Expect the first numbers to be aspirational. The mediator's job is to test each side's confidence, point out litigation risks, and search for overlap. You may hear proposals that bundle money with non-monetary terms, apologies, confidentiality clauses, payment schedules, or future business opportunities. There's no formula for making offers. You can't just double what you're willing to settle for and then just meet in the middle. Stay patient. Movement often accelerates later in the day. Mediation is a marathon, not a sprint. No one can force you to accept a deal. Your attorney will weigh the offer against trial costs, odds of success, collection risk, and the value of finally having closure. If you settle your case at mediation, then be sure that it is what you want and not because you feel like someone is forcing you to. Unfortunately, not all cases can be settled. If one side insists on having custody of the children, but there are founded concerns about their abuse or neglect of the kids, then it's hard to reach an agreement. This is why it is important for you to know what your red lines are prior to mediation so you don't cross them. An MSA is binding. Depending on your state, an MSA that contains the statutory magic language, the agreement is not subject to revocation, is almost bulletproof and must be entered by the court. In civil cases, MSAs are also enforceable under contract law. An MSA is 10 times stronger than a regular settlement agreement. So make sure that you are extremely clear in exactly what you are agreeing on. Courts will not and cannot fix sloppy settlement language, so accuracy matters. After mediation, one lawyer, often the plaintiff's counsel, drafts the agreed judgment, divorce decree, settlement agreement, or dismissal papers that mirror the terms of the MSA. A good MSA will include directions on who is drafting these final papers and will set deadlines for completion. However, don't rush the drafting of the MSA just because you finally reached an agreement. If you do not settle, this is called an impasse. If you impasse, the mediator will simply report the impasse to the court and there's no MSA for you to sign. Nearly every single person who has ever reached an agreement in mediation has had buyer's remorse in the days following. This is normal. This is a normal human feeling. So don't be surprised when it happens to you. We are programmed to wonder what if and to second guess ourselves. When that feeling hits you, just remember that you were always going to wonder what if, and then give it a few days for the feeling to pass. Be respectful. Mediators relay not just numbers, but impressions. Speak candidly in caucus. The mediator cannot help with information that you withhold. Bring snacks, medications, and a phone charger. Comfort sustains clear judgment. Remember your audience. You are persuading both the other side and the mediator, who becomes an informal advocate for your proposal in the opposite room. Bring a notepad so you can take notes and keep the offer straight. Mediation is not a sign of weakness. It is a strategic opportunity. Arrive prepared, listen closely, and be firm with what you need while being flexible with what you want. Whether you leave with a signed agreement or a sharpened trial plan, the day will move your case forward on terms that you helped shape. Here are some additional tips to help you prepare for trial, which are also incredibly helpful in preparing for mediation.